There we go. Find a case. No, it's running. Okay. And I am taking liberty to mute everyone's device, so we don't hear from you until we are ready for you. I guess Monica's supposed to be on for this.
And not if no one requested her.
Oh,
But she
okay,
typically does sign in, but
okay. Yeah, we did have 2 people this morning, so. Well, the calendar is small, but we definitely should have more than this amount of folks.
you know, we've got minus whatever came off. 20, 18, minus whatever came off.
Wonder if Daniel Green will be here.
Escaper is a tool.
What?
Zoom Escaper, tool that helps you escape Zoom meetings and other video conferencing scenarios. Allows you to self-sabotage your audio stream, making your presence unbearable to others. With an add-on.
That's what we like. I'm gonna wait about at least 3 more minutes, probably 2 minutes after, and make some announcements then, and then we'll get started. We even heard back from anyone on my question. Okay.
Oh, I did. I sent you a few responses, but nobody has the same problem yet. They have different problems. Some people's feeds are getting all scrambled, like it'll be.
Oh, so maybe there's just some issues with it that are.
Nobody so far has had your exact issue.
Okay.
Is that Alan Wagner?
Mm-hmm. He's got the tire brake case. That's his.
I thought his associate's name.
Oh. Well, he's here for the big money. Dwayne Brown, I need to keep that. You know, I'm reluctant to go ahead, even though some of these, let's see, defaults are ready to go. I could have a defendant or 2 pop on, and I don't want to. There we go, a few more people. So it's 1 o'clock. I'm going to wait 2 more minutes before I get started. I did anticipate a few other people being here, but. Say la vie. And that's Mr. Begner's client, I believe, Miss Dr. Hendler. All right, I'm going to wait one more minute and then we'll get started. And just to make some preliminary announcements, this calendar is being broadcast on YouTube Live. So any comments that are made here, besides being, there's no one in the courtroom, but they're also going to be broadcast on the internet. So just want to advise you of that. Let me go ahead and get started. This is a civil default calendar for April 6, 2021. My name is Diane Besson. I'm the judge presiding over this calendar. Got about 20 some odd cases on the calendar, although a number of them have already been resolved, and a fair amount also since the publishing of this calendar. Parties or counsel have submitted adequate documentation that I think many of these are going to be sort of pro forma. I'll be able to grant judgment because we now have all the proper paperwork. But let me go through and start. The first case, McCurdy Indemnity versus Santos and Marilisa Rivera. Is that you, Ms. Rivera? I see you also on the call. That case has been continued. Were you aware of that, ma'am? Oh no, I'm trying to unmute her. Here she is. All right, Ms. Rivera Martinez, were you aware that your case has been continued?
No.
Okay, so do you have an attorney on this?
No.
Okay, well, this is showing she's got Richard Evans, and I don't know if that's for Santos Perez.
Yeah, and I've got it continued for discovery.
Right.
So somebody's on the other side.
So, and there's no one else on the call that's handling this case, Deanna Smith or Richard Evans. All right. So this case is not going to be heard today, ma'am. They asked for some additional time, plaintiffs did, to gather some information. Did you receive the notice for today by mail or by email?
Email.
Okay, well, that's how you'll get notice then for the next hearing when that happens. I don't know when that'll be, but it'll probably be in about 3 to 4 months is my guess. Okay?
Yeah.
Do you have any questions at this time?
Your Honor, I'm here to translate. My name is Oscar Perez. So she just needs to wait for the notice to reappear.
Yes, and I guess what's happened, I'm just guessing from what I can see that there was a car accident involved and there's damage to a vehicle and they're trying to seek the difference from either insurance or there was no insurance.
Yes, the driver was Corina de Santos Perez. She is the vehicle owner, or was. The vehicle is no longer. So she wasn't aware on any of these, so she's kind of lost in the mix. But she received this in the mail, and she just want to, be present and make sure that she complains.
Okay, and so I'm going to have my staff attorney send her a more detailed email explaining what's happened and who she might reach out to if she wants to try and find out more about this case. Okay.
Yes, she needs that. I'm actually a friend of hers, and she's like, she needed a help. She's
okay.
Here.
And what's her, do you know how to chat on this device? Do you know how to send a chat on Zoom?
Yeah, we can try out. Yeah.
So down below on your screen, it says chat. If you'll click on that, you can send, Miss Abrams is going to send you a chat and she's going to ask for your email. And once you send that back to her, then she'll be able to give you some additional information. She's my staff attorney. Okay.
That sounds good.
And then you're free to go. Thank you.
Thank you.
Midland Credit versus James Pope, that's been dismissed. Midland versus Dennis Williams, That's been dismissed. Portfolio recovery versus Jacqueline Pena. Do I have
Good
counsel?
afternoon. Yes, good afternoon, Your Honor. Karen Leahy on behalf of Portfolio Recovery Associates.
So the only thing I'm missing, I did not see a business record affidavit, and I don't think the complaint was verified. Do you have something like that? Or a witness?
I don't, Your Honor. I can get a business records affidavit, but I don't have one today.
All right. How soon do you think you can get one?
Well, within 30 days.
So I may just have to put you on the next calendar. And then if you get it in ahead of time and I can grant the default, I'll be happy to do that. But for right now, without that, to prove the damages, I can't do anything. So we'll put you on our next calendar. It'll probably be, well, we already set that, didn't we, Amy?
It'll probably be in July, or we've already done June's.
Can we add her to June?
We can.
We'll add you to our June calendar if that's okay. It's the
Yes,
beginning
that's
of
fine.
June. Okay,
Yep.
great.
All right. Thank
Thank
you, Your
you.
Honor. That's my only matter, if I may be excused.
Yes, thank you. So we'll
Thank you.
reset that for June. Next case, Citibank versus Killpack.
Daniel Green for plaintiff, Judge. I believe,
We've
we
got
haven't-
everything.
okay.
So there was some conversation on an email that said that there's been a consent reached. Actually, that email was sent to Monica Walker, our court reporter. And it said from Mr. Killpack that he reached an agreement yesterday or the day before. Do you know anything about that?
Who was the email from?
It was from the defendant. It
I-
says, he sent it to Miss Bailey. I made a payment agreement with ARS National Services, so therefore I won't be on the call.
I don't know who that is, Judge. ARS National Services could be like a debt consolidation company. I would just go ahead and,
It says collection agency for Citibank, so
yeah,
I'm happy to grant the default. If he's got some payment that he's working out with them, he probably should have been here to tell us more about it.
understood.
All right, so I've got I've got the default judgment here for $5,229.07, costs of $311.55.
Thank you.
Okay. I suspect you've got some others. You want to let me know what those are?
Judge, they're all, I think they're
They s-
all in next anyway.
Midland versus Miss Weaver.
Yes.
All right, and that we also have a judgment. We've got everything we need for that. Let me see. A lot of this was sent in, oh dear. Just the last day. And so today is the 6th. And I've signed that for 3782.67. And so that judgment will be granted against Miss Weaver. So let me just go through next page. JP Morgan versus Neil Cameron.
Judge, we're filing a motion in that one. It should be filed by the end of the day.
Okay,
Even
yeah,
though
I've got, the
this is-
complaint wasn't verified and I don't have a business record affidavit.
This one, I was told, will be filed by the end of the day.
He was told.
A business record affidavit, do you think?
Yes, with our default packet.
Okay. Let's see if that comes in. If it does, I'll be able to grant, let me just say, a possible reset. If I get that today, I'll be able to grant it. If not, we'll put it on our next calendar. Next one, Midland Credit versus Coley. Is that one yours?
Yes.
And I have all the paperwork on that. I did get everything. So that'll be granted in the amount of $753.42. 21. So that one will be granted. The next case is Miss Stewart's case, Shaquana Stewart. In that case, I don't know if that's yours, but there was a consent entered into.
Liz,
Whose case is that? No one's here on that, but I have a consent, so I'm just going to sign this. That was signed by both the defendant and attorney for plaintiff. That was position 9. Position 10, One Main Financial versus Gary McCall.
Judge, I think that's Ms. Brown, yeah.
Liz Brown on behalf of plaintiff.
And I do have all the documentation now. I do have a proposed order. And I'm going to sign this right now, 2021. So that's judgment will be granted. That was all in order. The next case is Midland versus Roman or Romaine. Is that yours, Daniel?
Yep.
And that all the paperwork is in order. We did get everything filed before today. 6/20/21 for $1,065.93. The next one is Westlake Financial versus Almisha Lewis. I think the only potential question here was an issue of attorney's fees, but if they're not being requested, I have all the information to issue default. Is there someone here on that?
That's mine, Judge. I'm looking up,
Okay.
that should be,
So I do have all the proper
that should be
documentation.
pursuant to the contract.
It is, it's
For
85,
the attorney's
38,
fee.
53, prejudgment
our-
interest. I'm sorry, go ahead.
I was just gonna try and point you to the attorney's fees provision.
Right, and it's in there, and I've got a default judgment.
Oh, okay,
that's
okay.
Properly, yeah, I
Okay,
just signed it. So that one is good.
I'll,
Next case is State Farm versus Car Wash Partners. That's been dismissed. After that, On Deck Capital versus Progressive Footwear and Mark Dobbins.
Good morning, Judge Jason Cano on behalf of On Deck Capital.
And I believe you also, we got everything we needed. I don't know, the proposed judgment did not include attorney's fees. And so, but other than that, oh no, I'm sorry, $500 in contractual attorney's fees. That's right. And then I've got an actual default judgment and everything was properly submitted. So I've signed that. Did you have any other cases?
That's my only case today, Judge. May I be excused?
Yes, thank you. That'll be filed later today. Department Stores versus Oscar Kemp. And I see Mr. Kemp is on the call. Good morning, good afternoon, Mr. Kemp.
Hey, how you doing?
Good.
Judge, that one is one of mine.
So let me tell you, Mr. Kemp, you didn't answer the lawsuit. And wait a minute, let me make sure this isn't the one where there was the plaintiffs, which I think in this case is Macy's, has submitted everything that they needed to for me to issue a judgment in their favor for the amount of $7,392.83 plus costs of court. Were you aware of that, sir?
I'm not aware of what I owe them. I wasn't aware.
Okay. Did you get a copy of the lawsuit?
I got this thing in the mail. That's what I'm looking at now, but I don't recall getting a copy of the lawsuit.
Are you checking that right now? All right, just 1 minute, because my staff attorney is going to pull it.
New Year's on
December
December 30th.
30th. You have an address?
It personally served Oscar Kemp at 2360 Beach Way Southwest.
23
Beach Way,
Beach Way, Southwest,
Atlanta.
Atlanta. Back in December. Does that ring a bell, Mr. Kemp?
Yes, when the man knocked on the door. Yes.
Yeah, and so when he served you with the lawsuit, you were required to file an answer with the court, and because you failed to do that, I'm required now to grant them a judgment in the amount they're asking for. And I don't know if you're interested in talking to the attorney to maybe work something out, a payment plan. Mr. Green is also on the call. I don't know if that's something that you're interested in doing. I could put the two of you in a private room as part of this call for you to discuss that possibility. Is that something you'd be interested in?
Yes, cause, what are my other options? Do I have any other options?
You really don't at this point, unfortunately. I'm actually, unless Mr. Green tells me he's worked something else out, I would be obligated to grant them judgment for the amount that they're requesting.
Okay. I guess so if I'm not able to pay, then how do I go? Or what do I do from now?
Well, so I can't make you pay. The only thing that I can do, the court is issue a document, which is what I'll sign shortly. It'll be this default. And it will say that they are entitled to a judgment in a certain amount of money. How they collect that is up to them. There are a lot of legal ways that they can go about either garnishing wages, and maybe you can't pay it now, but maybe, I don't know if you're working or not, but when you start, if you're not working and maybe you start working or you own some property, they may be able to try and collect that money a variety of different ways, like garnishing a bank account or your employment check, things like that. But I can't make, obviously I can't, my only job here is to decide whether or not I am going to grant them a judgment in the amount they've requested. And based on what they've submitted to the court, I'd be required to do that.
Okay.
The only other option, I suppose, is if you want to get Mr. Green's email information and contact him after this court hearing and see who you might speak with. They'd much rather work something out and receive some amount of money monthly than trying to figure out how to get it from you, if that makes
Okay.
sense.
Yes, I can get the email then.
I would, Judge, rather just give him a phone number if that works better.
Okay. Do you
Yeah,
know?
That work a lot better for me.
All right.
A lot easier.
All right.
It's
Go ahead. Good, Daniel. Go ahead.
1-800 1-800-531
531
5499.
5499.
And when you call in, make sure you give them your file number, which is 3000 918
918
318.
318. Okay.
All right. So I've signed the order, Mr. Kemp, but if you're interested in working out a payment plan with them, they'd much rather do that than pay a lawyer to figure out how to collect the money from you that they may or may not get. Okay.
Okay. Thank you very much.
Thank you for being on the call. You're free to go, sir, if you have no questions.
All right.
Thank you.
Mhm.
The next case is a Legacy Federal versus Peter Harms. Is that yours also, Daniel?
Yeah, Judge, that's my last one.
And that appears to all be in order. They got the documentation filed before this afternoon. That's $26,681.69 principal. There's a prejudgment interest amount. There is a contractual attorney's fees and costs amount. So I've signed the default. That'll be filed later today.
Thank you, Judge. Good to see you guys.
Good to see you. See if you can get that paperwork in. If not, I'll have to reset that.
I
Okay.
think they'll be getting it in. That's what they.
Thank
swore
you.
to me. Okay, bye-bye.
The next case, Augusto Cotto versus Aaron Jordan, has been continued. I guess there was a death in the family. And then the final case is Kevin Hendler versus Mavis Tire Supply. So, Mr. Begner, I know is plaintiff's counsel. Is there counsel for defense? Okay, and before I hear this, Mr. Koffelt, are you here on a case?
Yes, Your Honor, Kofelt. I'm actually lead counsel for the hearing in the Hendler matter. In the Hendler versus
Oh,
Mavis
okay,
Tire.
gotcha. I gotcha. Thank you. All right, so there's no one here representing Mavis.
Correct, Your Honor.
Okay, then I'm ready to go forward.
Thank you, Your Honor. And just to kind of give you an overview of where we're at here, obviously we're on a default calendar, but we have alleged a number of counts in our complaint, including breach of contract, money hadn't received, et cetera. But what I want to focus on today is the count for fraud, since we are in a default. And, if this was the result of a verdict, of course, we'd have to elect between, a breach of contract remedy or fraud. I believe that this is more appropriate to sound in fraud, given the circumstances of the case. And we've also alleged attorneys' fees and costs, as well as punitive damages arising from the fraud count. Basically, the overview of the case is really straightforward and simple. Mavis Tire.
So, and just to let you know, I have been through the complaint. I'm pretty familiar with it. So I don't know if you're going to have Mr. Hendler, is it doctor? I thought I saw that somewhere, testify.
With each of the factual allegations being deemed admitted as if proved at this point, I don't see a need to have him testify as I take the court through the evidence regarding punitive damages.
Okay.
If it might be possible, he is on the call, so it might be possible that we need to call him to testify, but I'm going to defer to the court's preference on that.
Okay.
If you feel that there's some evidence lacking.
All right.
So with regard to the fraud claim, and I mean, if we, with each and every fact of the complaint being deemed admitted, which I'm assuming we're past at this point, would the court prefer me to discuss attorney's fees or to present evidence on punitives first?
It doesn't matter to me.
So I went ahead just to expedite things. I submitted an affidavit I filed as Exhibit 1 earlier today, which includes my affidavit in support of our request for attorney's fees. It includes detailed timesheets indicating each hour spent. It's actually pretty modest as far as an attorney's fees motion. It doesn't include anything that's been done today. It's only current through yesterday evening. Let me just pull that here. Got the exact amount.
You know what? I looked through all those exhibits and I think for some reason I started at number 8 and went backwards. And I think that was the only one I didn't look at was number 1.
Well, I filed them as exhibits 1 through 8, but when they uploaded to the e-file program, for some reason, it pulled them all into some crazy order. So they might not have come to you in correct order.
Okay. And I did see a lot of the, let's see, I saw the other documentation related to the car accident in New York.
Yes, Your Honor. And I do want to emphasize with respect to those, and I'll get into those in a little bit more detail in a moment. But I want to emphasize, of course, we didn't get discovery in this case because they refused to file an answer. So we never got to discovery. So the evidence that I can submit to the court on why punitive damages are appropriate and what the amount is only stuff that I was able to get from public records, news reports, things like that. But we do have some additional information that's not just media reports. There are 3 news articles in there about that crash in New York, just to sort of emphasize the severity of Mavis's conduct, even in our case where there were no physical injuries. So with regard, but going back to attorney's fees, so Exhibit 1 presented an affidavit. I think it presents sufficient information under oath to support an award of attorney's fees, not counting the time spent in preparation for this hearing, which was about 3.5 hours, plus time spent actually on the hearing. Just as of yesterday, total attorney's fees in this case were $8,082. That's based on 2 different hourly rates. As I note in my affidavit, my hourly rate increased from $3.30 an hour to $3.80 an hour partway through this case. That's reflected in those billing statements. That shift in my rate was the first in several years and applied to all of our clients across the board, except for, of course, our flat fee cases. And I don't know if the court needs a minute to review any of that or if you have any questions regarding attorney's fees.
So I do need to just sort of, I know this is very detailed, but I do need to swear you in and just have you attest that the information contained in here is accurate. So I'm just going to ask you to raise your right hand. Do you swear or affirm a testimony you're going to give in this matter is the truth and the whole truth?
I do.
Thank you. And so you've been practicing since when? 2013?
I was admitted to Georgia in 2013. After law school, I moved to Phoenix and passed the Arizona bar. My intention was to work for the Maricopa County Public Defender's Office. However, after passing the bar, I didn't pay the final $2,000 some odd because I didn't want to until I knew whether I was going to get that job. And that was in the middle of the recession. So I wound up not getting the job and moving back to Georgia after a couple of years in Arizona doing contract work for some attorneys out there. But I graduated in 2010. I've been admitted in Georgia since 2013.
Okay. And are you the only attorney that worked on this case? Primarily?
I'm definitely the only attorney that billed on this case, according to our firm's records.
Okay.
Mr. Begner has been involved, throughout sort of, fill him in and I'll brief him or debrief him on developments in the case. But I mean, I handled the billable work in the case.
Okay. So I'll go through some more detail. I've got it up on my laptop here, but it seems pretty detailed. So I'll go back through that. So you're seeking, I guess, the amount of hours, let me go back to that, was 19 hours, 19.3 hours. I mean, 19.73 hours is the time.
It's actually, that's the actual time spent, but as is customary in our profession, we bill by the 10th of an hour. The actual billable to our client was based on 23.4 hours. Again, only current through yesterday.
Okay. Not core time. Okay. And then so the only other fees you would be seeking would be the time on the call today.
Also 3.5 hours this morning, final prep and for this hearing. So it'd be I believe it's 3 hours prep this morning based on when I started, and then the time on the hearing.
Okay. And all right. I think that suffices. And as to attorney's fees. Okay. And then what else are you requesting?
We are also requesting punitive damages, Your Honor. In our complaint, we requested not less than $1 million in punitives. The basis to support that is, with punitive damages, I'm sure the court's aware, it's based on what it will cost to deter future fraudulent conduct in the future fraudulent conduct on the part of the defendant. In this case, Mavis fraudulently claimed that they replaced Mr. Hendler's brakes. They told him they'd replaced them. They made repeated representations to that fact. And it turns out they did not replace his brakes. I think you hardly need an expert witness to testify as to what can result when that happens, when you think you've got brand new brakes or your vehicle's been properly serviced, and it's not. Brakes are essential to the safe functioning of the vehicle. But there's also a clear pattern of fraudulent conduct on the part of Mavis. The inclusion of exhibits 4, 5, 6, and 7 are all related to an incident in New York State in which a limo that was inspected by Mavis on a couple of occasions, Mavis kept saying that it's good, your brakes are good. The New York Department of Transportation said, no, they're not, take them back. And then at some point, Mavis, without government authorization, smacks a sticker on it saying, nope, they've passed their inspection. And it's later discovered that Mavis actually did not do the work they said they did. They did not replace the brakes on that limo. One news story found at Exhibit 6 quotes a district attorney in the criminal case because the owner of the limo company has been charged with manslaughter and I think negligent homicide, which is all predicated on him either knowing or that he knew or should have known that the vehicle was not safe to operate. That's what the whole criminal case up there is based on. Well, defense counsel received from the prosecution exculpatory evidence showing that Mavis falsified their service records of that limo. They never actually did the brake work. They just told the limo company that they had. This is exactly what's happened in this case. And but for Mr. Hendler's ability to recognize that his brakes had not in fact been changed, that could have been him. Not only in terms of injury or potential death, himself, his family, other motorists, pedestrians, but had he run a pedestrian over, for example, because his brakes failed, he could have been charged with negligent homicide or manslaughter easily, just as the limo company in New York was. So in that instance, 20 people were killed in that one accident. Now, Mavis continues to deny liability, continues to deny that they ever had anything to do with that or that it was their fault. But the former manager of that Mavis Discount Tire has given a sworn statement to prosecutors up there that it is the custom in Mavis retail stores to falsify these types of documents to meet corporate sales quotas, that there's not enough time or personnel for them to properly service that many vehicles to meet the sales quotas. So as a matter of routine at Mavis, according to the store manager in New York, they routinely don't do the work they said they did. And in this particular case, it was a brake job. So as far as this being a pattern of ongoing fraudulent conduct that rises to the conscious indifference to consequences, as stated in OCGA 5112 5.1 subsection B, I think that we are there. I mean, we have, this is something that Mavis has continued to do nationwide. There's testimony. And again, we don't have access to the actual transcripts or statements because we didn't get discovery in this case. So this is pretty much the best that we can do as far as tendering the best evidence to the court possible. This case is still ongoing. Even the criminal case up there is still ongoing. But the conscious indifference to the consequences of telling somebody that you've changed their brakes or that you've performed necessary safety maintenance on a vehicle when in fact you know you haven't, and purely for financial gain, by the way, I think this is exactly the kind of case that punitive damages exist to deter. I would also argue that there's an even lesser standard that would apply here regarding breaching a fiduciary duty, because I think when you turn over custody of your vehicle to a mechanic and entrust that mechanic with your life, if he doesn't do his job right, you could die. I mean, a vehicle can be very dangerous if it's not properly serviced and maintained. I would argue that there was a fiduciary obligation of the auto shop to properly service the brakes, or at the very least not to lie about it. And the breach of that fiduciary duty also would also warrant punitive damages under a lesser standard.
So I do have two questions. I mean, I realize this is a default, but I didn't know, how did your client know that well, let me back up. Was this to just replace the brake pads, or was this to put new brakes on the vehicle?
Actually, Your Honor, it's funny because my client, and again, this is the part where we may want to call him up to testify, but my client has informed me that he went in there just to get new brake pads, but they informed him that based on how low the pads had gotten, that for safety reasons, he needed to replace the whole brake. And if the court wants to have Mr. Hendler on to swear to that under oath, we can certainly put him up, but he was actually talked into it by Mavis because they told him it wasn't safe to drive unless he replaced the whole thing.
Okay. So I guess that's the rotors and everything else. I guess they'd been warned if the pads were low. And then how did he know that this was not done? I mean, I don't know that I could look at my car and know did he take it somewhere else? Maybe he needs to sort of inform me. And again, I realize it's a default. So in essence, you've been successful on everything that you've alleged in the complaint, but I'm just sort of curious. So I'm asking these questions.
I completely understand, Your Honor. And speaking as somebody who doesn't even know how to change his own oil, I was curious myself. I really know nothing about cars, but Mr. Hendler does. It's sort of a hobby of his. He likes to work on cars. It's a fascination of his. Apparently he was able to tell pretty quickly that the brakes had not been changed. I mean, I do know this about them. They make that awful nails on chalkboard noise when they really need to be replaced. So I don't know what Mavis was thinking, because even I would know if they did not properly change my brakes, if they were that bad. Mr. Hendler, who knows way more about cars, I'm pretty sure he knew the second he got home. But if the court wants to hear from him, we can certainly swear him in. He can give a more detailed response.
And the only other reason I asked is my car, the brakes on my vehicle routinely squeak, and it's not a defect. So I don't know. I guess I'm going to ask Mr. Hendler. Mr. Hendler, if you could raise your right hand, please. Do you swear or affirm the testimony you're going to give in this case is the truth and the whole truth, sir? You need to unmute your device. There we go.
Yeah.
You do. Okay. So I'm just sort of curious how you knew that the brakes or the pads or whatever it was were not replaced.
Well, I looked at them. I just happened to be looking over the car, and you could look through the wheel and you can see that the new rotors would be perfectly smooth across. There'd be no rust on them. These, as the brake pads wear, you can see a little groove on the edge of the rotor. And I noticed the groove was there. I also noticed that the rotors were pretty rusty, and I would think that new rotors shouldn't have done that. And then looking sideways, you can actually see the thickness of the pad, and they were obviously worn out pads.
Okay. You since have had them replaced?
Yes.
Okay. All right. I'm looking at my staff attorney to see if she has anything further. I think that, I don't know. Yes.
I'm sorry, may I follow up with one or two questions while I still got them? Mr. Hendler, can you also describe for the court what, if anything, happened when you notified Mavis that you didn't believe they'd properly changed the brakes?
I took the car back and they looked at it and they somewhat agreed. And at that point I said, I just want my money back, because I didn't trust them to do any repairs after that, and figured I'd get it repaired. And that's where the whole thing started. It was just phone calls and a lot of time spent and just constantly being stalled and put off and calls not returned.
And apparently some lack of cooperation from your credit card company.
I learned something interesting there. They originally credited the money back and I thought I was done, but then, and I just thought it was done. I didn't notice it. And several months later, I'm looking at my credit card statement and realized something just didn't seem right, because normally I just pay the balance. And that's when I called them up and they said, well, basically Mavis said that they didn't owe you the money and that they were the ones that would have to refund it. So we had to charge it back. So I just thought credit card companies could refund the money, but apparently Mavis was able to say no, and I got charged back.
Okay. That's new to me too. All right. Anything further from counsel?
Mr. Hendler, just one last question. When you were there the first time, when they claimed that they had replaced the brakes, did you request anything from them? And if so, what was it?
Right. That was actually one of the things that sort of tipped me off too, is when they replaced the brakes, I said, I would like the old rotors because I just have a collection of them. And when I picked up the car, they weren't in the back of the car. And I questioned them on it. And they said, oh, we forgot to do it. Just go grab a couple out of the bin over there. So I took, they gave me 2 random rotors that weren't off my car. And then I started to think, well, gee, if they didn't put the old parts in the car, did they actually replace them?
Thank you, Mr. Handler. I think that's all I have for him, Your Honor.
Okay. I don't think we have anything else. I'm going to take this under advisement and think a minute and just go through.
I'm sorry. I don't mean to interrupt the court.
Go ahead.
I just wanted to also point out that the evidence of a defendant's circumstances and financial condition are also admissible in the punitive damages phase. I just want to direct the court's attention to one specific part of that massive document I submitted as Exhibit 8. And specifically, most of this stuff is just not really relevant, but I wanted to submit the whole report. Specifically, I want to direct the court's attention to page 97 of that report.
Let me pull up, let me see, this is the one, page 97.
Yes, Your Honor. And I've actually taken the liberty of highlighting the relevant information. And as far as the defendant's ability to pay and what amount of punitive damages would be sufficient to deter this conduct in the future, first of all, apparently 20 casualty car crash in New York years ago wasn't enough to scare them into changing their policies. Of course, that case hasn't actually concluded yet and won't for some time. But looking at how much revenue this corporation took in just in 2020, this is data last updated on September 11 of 2020. Their annual sales were $3,027,643,382. So to put that in perspective, Your Honor, if the court were to take that into consideration, as Georgia law allows, in terms of what is appropriate for punitive damages, 1% of their revenue, if that were the punitive damages awarded, would be $30,276,433.82. 1/10 of 1% of last year's revenue for Mavis, if that were the award, would be $3,027,643.38. Now, I don't know that 1/10 of 1% of last year's revenue is enough to make them change. I do know that I didn't have this information when I drafted the complaint. I think I may have lowballed it, honestly, because if punitive damages are meant to deter and human life and their, like I said, fiduciary duty to their customers, if that and the value of human life aren't enough to deter them, and they're bringing in $3,027 million and change each year, I don't think $1 million is going to get it done. I don't even think 3 million is going to get it done. That's 1/10 of 1%. I'm not sure what amount the court is comfortable with. And I know this is a default hearing, but here's the thing. Besides not answering the complaint, I did something I absolutely did not have to do. I served them with my motion for default judgment by certified mail. The return receipt is at Exhibit 2.
I saw that.
That's not 2, it's Exhibit 3. I didn't have to serve them with additional notice that I was filing a motion for default. I did it anyway because we believed that at trial we could prove punitive damages and we would win. And I knew that it was possible the court would be reluctant to award a 7-figure punitive damages judgment without the defendant here. But they honestly cannot come back later and say they didn't know about this. I served them with the complaint and we served them unnecessarily with notice of the motion for default. They still have not shown up to defend it, probably because they think that a court's not going to award punitive damages by default. But that's the risk they've taken. That's what they've chosen to do. They can't come back later and say they didn't know that this was a possibility. Maybe they don't care because they think they can afford whatever the award will be, but punitive damages are meant to hurt. And it would take a lot to hurt a company the size of Mavis.
All right. So something else, I'll take a look at all this. I also have to consider the cap, the punitive cap, but I guess we'll take a look at that. Okay. Well, thank you. If there's nothing further, thank you everyone for being on the call. Yeah, I don't know who, Mr. Cameron, did you have a case on today's calendar?
Yes, I believe I did, and I apologize. I've got 2 different dates on here, so I just missed the wrong date. So I don't know if I can reschedule or It says it's actually for April 6th at 1 o'clock, and I obviously it was late for that, so I apologize for that. But I had another piece of paper that had a different date on it. It was for the 9th, so.
Okay, so this was a JP Morgan
Yes,
versus Neil Cameron.
yep.
Okay. So the attorney for JP Morgan Chase was on the call. Did we definitely reset it or tell him to get the documents in?
If he gets them in before the calendar.
So what happened, and the other parties are free to go, thank you. But Mr. Cameron, as to your case, the attorney did not get in to the court, did not file the court one of the documents he needed for me to grant the default today. And the case is in default because apparently they filed suit and you did not respond to the lawsuit.
I didn't get the mail, so I didn't get any mail messages, and I just got served like a month ago. So all I can think of was that maybe the mail was going to my old residence where my ex-wife resides, and I did not get any of the paperwork. So
But this would have been, did you get paperwork about the original lawsuit?
yeah, and then I got some company that called me to try to collect from me, and I looked them up, and they didn't seem like they were a credible source. And I'm more than willing to pay this money now at this point. So because again, it was during my divorce that these costs were incurred, and I'm more than willing to pay this balance off. So
I'm going to have Miss Abrams, my staff attorney, not to. Oh,
yeah, because I wasn't actually receiving any of the things from Chase. So
He's not the in-house counsel.
So how can we get him to someone to?
If he'll give me his information, I'll forward it to him.
Okay, do you know how to use the chat on the Zoom call down below? It should say chat, or if you will chat to Miss Amy Abrams.
okay, sure,
Your what, phone number or email? Phone number and email.
sure.
We're going to get that to the attorney who represented the party today and see if they can't reach out to you and maybe work out a payment plan. I can tell you they'd much rather get paid or work out a payment plan than just have a judgment and then try and collect it.
No, I mean, I've been more than willing to pay, but like I said, this collection agency called me, and I looked them up, and it didn't seem a legitimate collection agency, so I was hesitant to pay them or even start a payment scheme with them. So
Right, and that might be an oxymoron, right? Legitimate collection company.
Well, no, because I mean,
I'm agreeing with you.
because they didn't give me any kind of way to pay it other than through like a paper check to a mailing address, and it just made me very nervous. So
I was just going to look. I was trying to see what the amount.
it was
Late fees. Oh, it's not very much. Well, I guess I think they've got listed here about $800. I don't know exactly, but we'll get that information to the attorney, and he'll reach out to you. And if you're willing to pay or make an arrangement, he'll contact you, and maybe we won't see you again. Okay?
Yeah, no, absolutely. I'm definitely willing to pay it, and hopefully have it not reflect negatively on me. So
Okay, great. Thank you. You're free to go, sir.
okay, thank you so much.
Thank you.